staying with matters that have to do with the courts. The Gauteng High Court in Pretoria is tomorrow expected to hear an application by the Presidency to recoup over 28 million rand in legal fees accrued in former President Jacob Zuma's cases. The matter follows Zuma's battle in the courts since 2018 over his alleged involvement in the controversial multi-billion rand arms deal in 1999. Newzroom Afrika's Zoleka Qodashe has been tracking that story and joins us now live. It's been going on for many years, this case, with lots of organizations and political parties, to name the DA and the AfriForum, to name a couple, saying he must pay back the money.
That's correct, Vuyo. Good afternoon, and good afternoon to the viewers. Well, this matter stems from a very long time ago. In fact, its genesis is in 2018 with an application by the Democratic Alliance as well as the EFF that sought to review and set aside the state's decision to actually provide funding for Zuma's legal fees. Now, that matter, of course, the two parties were successful, and the Gauteng High Court in Pretoria reviewed and set aside the state's decision, also finding that its funding in legal fees for former President Jacob Zuma was invalid. And so to that extent, the court set it aside. But another order of the Gauteng High Court in Pretoria was that the state attorney must provide a list and full declaration of the funding that was provided to former President Jacob Zuma, as well as means that they will be seeking to actually recoup this 28 million rand in legal fees that they had actually provided to the former statesman. Now, after that, the state attorney then began with civil proceedings for that after the former president launched an leave to appeal application before the Supreme Court of Appeal. Of course, that was dismissed. So in 2021, the state attorney then began with measures to ensure that that 28 million rand would be recouped. And so that is what lands this particular matter in the Gauteng High Court in Pretoria. But I think what's also significant, Vuyo, is that when this matter in 2003, when the former National Deputy National Director for Public Prosecutions, the NDPP, indicted Shabir Sheikh for the charges of corruption in relation to the Talis matter, the DG in the presidency, that was then Reverend Frank Chigane, wrote a letter for motivation to actually provide legal fees to former President Jacob Zuma, who was then the deputy president of the country, for the provision of legal fees in assistance with this particular matter. And so that essentially made that particular order or motivation have a retrospective effect in relation to the assistance that would be provided by the state to the former president. Now, the retrospectivity in law means it has a backdated effect, meaning that it has an effect for matters that happened prior to the actual matter that is in question. And so that is how the former president then had those legal fees or assistance in legal fees provided to him. And so that is what lands the matter before the Gauteng High Court in Pretoria tomorrow, because the state attorney has to ensure that that 28 million rands, over 28 million rands, is recouped in order and to give effect to the order of the Gauteng High Court in Pretoria in December of 2018. And so that is what the applicants will be seeking tomorrow. Of course, this matter is between the presidency as well as former President Jacob Zuma. So because those legal fees were accrued in his personal capacity, not in line with the State Attorney Act, then that is why he has to recoup those funds. In fact, there was an agreement that if the former president were to be found to be convicted in the charges that have been leveled against him, then he would have to repay that 28 million rand. And so that is what the applicants will be seeking before the Gauteng High Court in Pretoria tomorrow.
It's quite interesting that things are at this point, Zoleka, because, I mean, back in the day, many moons ago, Michael Hurley, who was the former president's lawyer, had made an undertaking that the former president would repay the money should the court find that he had acted in his personal capacity.
That's correct, Vuyo. And remember, I think it's Section 3 and Section 5 of the State Attorney Act stipulates that these funds that will be provided for members of the executive must be provided to them when they are executing their functions in line with the Constitution. And so because that was in his personal capacity, that is why the DA and the EFF actually brought this review application before the Gauteng High Court in Pretoria, because that was in his personal capacity and not in the functions that he would be performing as the deputy president at the time. You'll remember also, Vuyo, that this does not take place in isolation. There's also an application that has been launched by the NPA in which it seeks to have the matter in the High Court in Pietermaritzburg continue despite any appeal that would be followed or rather launched by former President Jacob Zuma. Of course, this matter has been in the courts for quite a lengthy period of time, and so the NPA now seeks to have that matter continue even if the former president launches any kind of appeal. Of course, this would be unprecedented because when an appeal is launched, it means that any other matter is suspended until the appeal has been fully fledged out and has been heard. And so that is what is taking place on the sidelines of this Gauteng High Court in Pretoria matter, in which the applicants seek to have that over 28 million rand repaid by the former president, Vuyo.
Zoleka, Qodashe, out ahead, of course, of that case being heard tomorrow in Pretoria.